This is John Watson. I want to thank you for watching this video. We're going to cover a recent decision, March 17 of this year, and it relates to mortgage companies and the Fair Debt Collection Practices Act, as well as RESPA, which has to do with the laws governing servicing companies. And this is from the Northern District of Georgia. And first thing I'll point out is this was filed pro se, which means that the plaintiff did not have a lawyer. He filed this without a lawyer. He filed it in state court, but because he alleged these federal laws, it was removed to federal court. And what he says is that he got some notices from the foreclosure law firm, this McCullough Raymer, and that Nationstar violated the FDCPA as well as RESPA. And this was first reviewed by what's known as a magistrate judge, and then the federal district court judge looked at what the magistrate judge did, and basically we're going to see that approved everything the magistrate judge did. So the two defendants, Nationstar and McCullough, filed motions to dismiss. That basically says, hey, take everything that the plaintiff says as being true, the plaintiff still loses. We still win. And so let's look at these two federal claims first. And what the court found is that Nationstar could not be sued under the FDCPA because it only applies to, quote, debt collectors. And the plaintiff does not allege sufficient facts that Nationstar qualifies as a debt collector. Now, this is very important. When you're suing somebody under the FDCPA, you have to say, they are a debt collector and they violated the law. And you have to allege the facts that support that. And what the law says is that a mortgage servicer, or I'll do the quote here, mortgage servicers are not covered by the FDCPA. Now, a lot of times defense lawyers want to stop right there and say, see, mortgage companies, the FDCPA does not apply. But that's simply not true. The rest of the quote says, if they began servicing the loan at a time when it was not in default. So what that means is if your loan is in default or allegedly in default, and that can mean 1 day past due, past your payment due date. And that's when the mortgage company, such as Nationstar or Wells Fargo or Ocwen or whoever it may be, if that's when they get the loan, then normally they're going to be considered a debt collector. And I'll tell you this, Nationstar has just been buying thousands upon thousands of loans that are in default. And so normally when Nationstar is involved, they are a debt collector. But here the plaintiff did not allege that, and so he lost those claims. Now, he also alleged that the foreclosure lawyers were debt collectors, and the court said, okay, I'll buy that, they're debt collectors. But you did not allege that they violated the statute or did not establish that. And so there were really two parts to it. First of all, the plaintiff said they continued debt collection activities after receiving the alleged debt verification request. That's where you send a letter and say, hey, I want you to verify or validate this debt. And the court pointed out, well, it's true that a debt collector has to validate the debt, but only if they want to continue to engage in debt collection. So you can send a validation verification letter and the debt collector says, well, I'm not going to do anything else. Well, then they don't have to respond to you. And there's a lot of confusion about that, but that's what the law is. Then the plaintiff said, well, they sent intentionally confusing and deceptive letters. And the court said, no, just failing to list the address and telephone number does not violate the FDCPA. And the court pointed out we have a standard called least sophisticated consumer, but it does mean that you have to be willing to read the letters and apply some common sense. So the FDCPA claim against McCullough was dismissed. Now, the only RESPA claim right here is against Nationstar. And there were two parts to it. One, when a servicer takes over the servicing of the loan, they're supposed to notify you. But the plaintiff failed to allege facts showing that he had any actual damages, and actual damages can be mental anguish, or that Nationstar has a pattern and practice of not complying with RESPA. Well, the plaintiff did not allege those. And then the plaintiff failed to properly allege that he sent a qualified written request, QWR. That's a letter sent to a special address, and you request information about servicing. Now, after this lawsuit was filed, as of January 2014, we have a lot more tools available. We have something called request for information, something called a notice of error, that are kind of like, you might say, a subset of a QWR or related to a QWR. But back when this was done, the plaintiff just sent a QWR, but he did not allege actual damages, and the court found that the letter that the plaintiff sent does not even qualify as a QWR because it went well beyond mere servicing. Now, we can go beyond mere servicing when we're talking about a request for information, a notice of error, but back under the law of this case, what the plaintiff did apparently was not sufficient to qualify. So therefore, that was thrown out as well. And since all the federal claims were thrown out, the court said, you know what, I'm not going to hear the state law claims. I'm going to send those back to the Georgia State Court. Now, two things I'll point out. One, when somebody files a lawsuit without a lawyer, and I'll tell you this, if you're in federal court without a lawyer, you have a very tough battle in front of you. But they're going to liberally construe, in other words, give you a little bit of leeway, but see, this nevertheless pro se plaintiff must comply with threshold requirements of the Federal Rules of Civil Procedure. So if you're acting as your own lawyer, you've got to know the rules that the lawyers operate under. The other thing I'll mention is it's important to properly allege things in the lawsuit, because this person may very well have had the Fair Debt Collection Practices Act and RESPA violated by Nationstar and McCullough-Raymer, but he didn't properly allege it according to the federal judge. And so we have to make sure we're alleging things correctly in our complaint if we want those complaints to be able to survive this first attack, which is a motion to dismiss. So I hope that this has been helpful to you. If you live in Alabama, have questions about your mortgage company or questions about the FDCPA or RESPA or these new RESPA rules, then feel free to give us a call, 205-879-2447, or you can contact us through our website, alabamaconsumer.com. Thank you.